Thank you. We'll get started today. I would like to thank everyone for taking the time out of their busy schedule for today's session. This has been a great first half of a season for ITM 21st University in 2016, and we've provided well over 1,000 hours of CE credit so far this year. Some housekeeping. First of all, the handbook for this session is on our website. If you don't have it already, that handbook tracks along with the PowerPoint and provides a note section that would be useful. If you do not have it, go to www.itm21st.com. That's itm21st.com, and click on Education. Also, there will be the CE attendee form at the same spot for both CFP and CTFA, and this session has been approved for 1 hour of CE. As a reminder, those of you who are from FIRMA, the Fiduciary Investment Risk Management Association, you can also get 1 hour of CE by filling out the form. So if you want to get CE, just go to the website and fill out the form and send in according to the directions. Last, during the session, you can type in any questions that you might have. If it seems that it would be important to stop the session to answer the questions, we will. If not, we will hold them until the end. Okay? Before we get to today's session, let's take a look at our next session. As we mentioned, we've had a great first half of the year here in 2016, and before we take our summer break, we have one more great session. We had Alex Ryan earlier this year in a well-received session. Alex is of counsel at the Groom Law Group, and he provided us with a review of the proposed DOL fiduciary regulations. Now Alex, who is an expert in fiduciary matters, especially as it relates to ERISA plan sponsors, administrators, trustees, and financial service providers, is going to provide us with his review of the actual regulations. You know, there are a lot of articles written by a lot of pundits on this matter, and Alex is a true expert, so it'll give you a chance to learn firsthand from someone who lives and breathes this stuff and is an authority on this hot-button topic. And speaking of people who live and breathe the topic and are an authority, Barry Flagg is someone I have known for a number of years. A true life insurance professional, Barry is an advocate for the use of prudent investor practices in the selection, the purchase, and the management of life insurance. He started in the fiduciary investment business and built a successful life insurance practice by applying those same prudent investor management principles to life insurance. He lives that and is a driving force behind the best practice standards for life insurance, one of the best guidebooks for use with life insurance. Barry is the inventor and founder of Veralytic, the only patented online publisher of life insurance pricing and performance research and product suitability ratings. It is the morning star for life insurance. He has spoken on many occasions in person to many CPA and legal conferences as well as insurance industry events. He has been published in ABA, AICPA, and FIRMA publications, as well as trade publications like Trust and Estates magazine. Most recently, he was recognized in the BNA publication as a leading expert in applying established and proven asset management principles to the prudent selection and proper management of life insurance. I could go on, but would just like to say that we are happy that Barry is part of the ITM 21st University faculty and are grateful he's here today to talk about 10 questions every trustee or advisor should ask before a client purchases or continues a life insurance policy. So take it away, Barry.
Thanks, Mike. The 10 questions that we'll talk about today actually came from one of those speaking appearances or lectures that Mike mentioned. I was speaking about the application of prudent investor principles to life insurance and what has been my experience of the disparity between life insurance industry operating principles that we'll talk about and fiduciary industry operating principles at the Notre Dame Tax Institute. One of the lawyers there and I got to talking more about it after my participation in the panel, and that turned into an article, the article that he wrote, and I served as technical editor for Bloomberg BNA that Mike mentioned. As Mike also mentioned, I started in the fiduciary business first. I sought to diversify my resume early in my career, took a job as a analyst in the life insurance business. I started as an analyst in the pension investment advisory business, so I thought that was a natural way to broaden my resume. And as you saw from the picture on the previous screen, I'm only half joking when I say I pulled my hair out trying to do the things that were basic duties to perform in the investment business, and that were literally impossible in the insurance business. So what I'm going to try to do today is apply the 10 questions from the Bloomberg BNA article. For the most part, it's not an exact transfer, but I'm going to address most of the 10 questions. I mentioned the BNA article. I'm going to add another one or two, and I'm going to apply it to Mike's presentation, which I thought was just excellent last month, to give you a tool or some questions that can help you actually put into practice what Mike talked about in last month's presentation. So jumping right in, the first question in the BNA article is, what does it take to become a licensed agent, and how to choose them? And for purposes of our presentation, some may be asking, well, why is that relevant? Well, I referenced this difference between the operating principles of the life insurance business and the operating principles or the operating system of the fiduciary investment or the fiduciary business. And I analogize that, I've got both an Apple iPhone and a Microsoft Surface computer. I love them both. I think they're terrific. But if you try to run an Apple iOS app on a Microsoft Windows machine, nothing good happens. And I think that's been analogous to some of the experience that at least I've seen in my career, and that many of you may have experienced, that relying on outputs from an operating system that's not consistent with your operating system can cause problems. Mike also said last month, that fiduciaries, that ITM 21st, and fiduciaries in general look at life insurance differently than most agents or brokers. That's not a judgmental comment. That's not a comment that says it's one way is better than the other way, but it's just different. So as a fiduciary who has responsibility and liability for the performance of certain duties, understanding what it takes to become a licensed agent, to identify those who are most apt to support your duties, is at least was a useful question for the Notre Dame Tax Institute and the BNA article. Those differences come in licensure. Mike also mentioned last week that some agents and brokers are agents for a single company, and some are agents or brokers for 3 companies or 10 companies or a handful. Some are licensed to sell or place certain types of life insurance, only certain types of life insurance products. Some are licensed to sell all types of life insurance products. And as that relates to fiduciary duties, your obligations are to the beneficiaries without such constraints. Beneficiaries don't care if the agent or broker is licensed with 1 or 2 or 3. The duties for a trustee are to do what's in the best interest of the beneficiary without such constraints. So understanding the licensure constraints or not of the agent or broker. Certain agents or brokers have designations. I would encourage you to work with agents and brokers that have designations. Some of those designations include in the codes of ethics that they put the client's interests either ahead of their own or first. So that would be an alignment of their operating system with your operating system. Some designations have oversight, disciplinary boards to ensure that when practitioners, when agents or brokers deviate from that client's best interest standard, there is an enforcement or disciplinary action. Some designations do not have that. So talking about the designations, finding agents or brokers that have designations, that have a code of ethics, that put the client's best interest first, and ideally has some type of oversight, are the ones that will most likely be able to, again, align themselves with your operating system. Fiduciaries have a duty to understand and avoid conflicts. Compensation is certainly one of those conflicts. There are some agents brokers who suggest that being fee only eliminates conflicts. I'm here to tell you that there is no such thing as eliminating all conflicts. There are always conflicts, so understanding the conflicts is just part of the reconciliation of the life insurance industry operating system versus the fiduciary industry operating system. For instance, there are on the order of 3 insurers that manufacture fee-only products. And there are hundreds of insurers in the marketplace. And we'll talk about the variance, and Mike talked a little bit about the variance in pricing between one insurer and another. So if you only have 3 to choose from, that's a constraint or a conflict of the fee-only planner versus a commissioned agent who can or at least is willing to negotiate commission concessions and reduce compensation maybe to a fee-only level, or at least disclose the compensation. So moral of the story is it would be ideal to seek out or work with agents or brokers who are willing to be compensated in either fashion, again with disclosure. And all of this comes down to, again, this difference between insurance industry operating systems and the insurance industry operating system, what I call the operating system, and the fiduciary industry operating system, which I'm going to talk a little bit more about in question 2. So the life insurance industry operating system, by my view of the world, starts with or focuses its decision-making on the expected outcome. And that expected outcome is portrayed in these illustrations that Mike talked about last month. The rules and regulations from the insurance industry operating system don't focus on process. They focus on trying to make the illustration easier to understand and to publish rules that ensure that the illustrations do not or try not to mislead purchasers of insurance. The regulation that does that is called the Life Insurance Illustration Model Regulation Act, and then it's adopted by the various states. Life insurance is regulated by individual states. Most states adopt very similar rules from state to state. But what is interesting to me is some 20, 30, some decades later, this model illustration reg was updated because the illustrations that use apparently identical crediting rates were actually illustrating different rates. So in other words, before 2015, there's some risk that you were looking at an outcome, and Mike referenced this last month, an apples to oranges outcome if you were comparing illustrations. So this is just one example of how the industry is even published a rule to try to address the apples and oranges comparisons and as Mike said, it's not black and white. The decision-making process is just not black and white when you're looking at expected outcomes, particularly when you're looking at illustrations, even with the updated regs. But the most important part is that's not even consistent with the fiduciary operating system. The fiduciary operating system is about process. It's not about the outcome. It's about process prescribed for life insurance trusts, most importantly by the Uniform Prudent Investor Act, which Mike also referenced last month. And part of that, and I'm going to go over some things that I know are old hat to fiduciaries, but I'm going to just reference them here so that I can then tie them to life insurance in a little bit. The fiduciary, I'm not here to say that they don't care about the outcome, but the outcome is not as important as the process, and the process includes a duty to examine the information that is likely to bear importantly on the value or the security of the asset, of the life insurance policy. And it's a process that over the last 200 years has evolved and proven to increase the probability. It doesn't guarantee that the outcome will be achieved, but if you follow the process, if you do the things, if you perform the duties prescribed by the process, then it increases the probability, does two things. Increases the probability that expected outcomes will be achieved, but just as importantly for businesses on this call, for trustees and trust partners on this call, it protects you even if actual results underperform expectations, because again, the measure of your performance is not whether or not you achieve expected results, it's whether you've done certain things. So we'll talk a little bit more about those certain things. Mike also mentioned this last week, so I won't spend much time on this, but certainly looking at costs, as Mike mentioned, is important, not just because I have a business that measures those things, but because the Uniform Prudent Investor Act says that it's important, and Mike last month said it's important. So what's the cost of a life insurance policy? Well, is it the premium? Last month we talked about it wasn't the premium, and we even have case law that says it's not the premium, which I'll come back to. So if it's not the premium, then what is it? Sorry, I got ahead of myself. If it's not the premium, what is it? That's another question that we'll come back to. I'm going to stick with the fiduciary industry operating system. So the first thing that prudence says bears importantly the value of the security of the asset is looking at costs. The next thing that bears importantly on the value of the security asset, according to the Prudent Investor Act, is setting reasonable expectations as to the rate of return. And Mike talked a fair amount about how universal life illustrations used an unrealistically high rate of return in the 1980s, and variable life illustrations used an unrealistically high rate of return in the 1990s, and IUL illustrations are arguably using an unrealistically high rate of return in their illustrations now. And I don't mean that categorically. It's just there's a risk that the interest rate reflected in an IUL illustration is unrealistically high, and we'll talk about in another question how to consider that. The financial services industry, with this movement toward clients' best interest, toward moving the industry towards a client's best interest standard. Next month, or the next webinar is going to talk about the DOL regs, which impose a client's best interest standard on rollovers. So the same protection that a participant enjoys inside the qualified plan, they will now enjoy that same client's best interest protection on rollovers to IRAs. FINRA has also taken a number of steps toward more of a client's best interest posture, and issued a rule, not necessarily as part of this recent movement, but some time ago issued a rule that said it is inappropriate to compare a life insurance policy to another based on hypothetical performance, because if you're not looking at costs, then the communications would be misleading. And this goes to the fiduciary. This relates to, even though I know FINRA doesn't have jurisdiction over ILET trustees, this speaks to the fiduciary's duty to be prudent in their either delegation or decision making. And when the chief regulatory body of the financial services industry says that comparing illustrations is misleading, that's probably an inconsistency between the life insurance industry operating system and the fiduciary industry operating system. Even the Society of Actuaries, for products not under the jurisdiction of FINRA, have said that comparing illustrations is fundamentally, for the purpose of determining which product is better, is fundamentally inappropriate. And Mike talked a little about the OCC Handbook for Unique and Hard to Value Assets and how it's important to understand each policy or employ an advisor who can understand each policy and who's not affiliated with an insurance company, and that whether or not a replacement should be considered, should be considered. But at the same time, that book also cautions that these policy illustrations are subject to a high degree of fluctuation. So it cautions against the prudence of relying on something that is as a decision support tool, comparing something that has a high degree of fluctuation to something else that has a high degree of fluctuation, as something that may not be the best decision support tool. Maybe another example of the difference between the life insurance industry operating system and the fiduciary industry operating system. And because of these differences between the life insurance industry operating system and the fiduciary industry operating system, in my view, there's been more, it has been, that difference has been the cause of much litigation over the last several years. Mike mentioned the Cochran Key Bank case. I personally think that is a perfect example of this difference between the life insurance industry operating system and the fiduciary industry operating system. There's a Trust and Estates article that I co-authored that I'll talk about at the very end, that if anybody would like a copy of it, I'm happy to get it to you. But it's not just that case. There have been a number of other cases which we can talk about if we have time, but I do want to reference one of them. Earlier this year, a verdict was handed down against Goldman Sachs for breach of their duty to advise on life insurance. It involved one reputable agent running illustrations at the point of sale, and then some years later, about 10 years later, another reputable agent ran illustrations as part of a placement. The difference in premiums was $14+ million, and so the client sued, actually the advisory subsidiary of Goldman Sachs, but they sued for $14 million, and in my reading of the case, because the fiduciary couldn't tie the performance of their duties to Section 7, to Section 2, to prudent investor principles that the court could then understand, it was one expert against another, and so they ran the risk of, if I can't win the beauty contest, I lose $14.2 million, and that's exactly what happened. Mike also mentioned the 401k litigation, the increase in 401k litigation last year. I agree with him that I think there is if not direct, very related parallel. The litigation in 401k right now has to do with trustees not being mindful of what's being charged, and so the beneficiaries, the qualified plan trust beneficiaries, are suing the trustees because the trustees overpaid, and because they overpaid, the beneficiaries received less. And I think there's a direct parallel there. It's not terribly different. It's not the exact argument they made in the Cochran case, but it's similar. In the Cochran case, they argued they should have received more death benefits, and had they argued what 401k participants have been successfully arguing, that had you not been overcharged, had you not allowed yourself to be overcharged, we would have received more death benefit. I see that seems to me to be a risk. So lastly, Mike mentioned the best practice standards for life insurance stewardship. What he didn't mention that's also worthy of note is ITM 21st was on the panel of the 17 professionals that vetted the standards. So this is a product that has been critiqued and vetted by nearly every member of nearly every profession of the financial services industry who have clients who own life insurance. So I think I'm a little bit biased because I had a hand in it, but I think it's a very worthy checklist for fiduciaries to, again, try to reconcile these differences that I've talked about between the fiduciary industry operating system and the life insurance industry operating system. Not trying to teach you the insurance business, but I think it's a good checklist for reconciling those differences. So question number 3, and I'm not going to spend as much time on all the questions. That was a kind of involved one. Question 3, Mike mentioned term insurance last week. It's clearly the easiest to understand because he went into it in some depth last month. I'm not going to go into it in as much depth here, but he mentioned there's fixed premium for annually renewable, so where the premium changes every year, or fixed for 5 or 10 or 20 or 30 years. This is more of a marketplace term than it is a legal term, but Mike talked about guaranteed universal life, which looks and smells and tastes a lot like term insurance. Doesn't have cash value. It's got a fixed premium. It's got a fixed death benefit. And so I often think of that as flexible premium term because you can change the premium to change the duration. But the 2 things I do want to speak to is the importance of thinking about the coverage duration in terms of life expectancy. Term insurance companies or insurance companies don't issue term insurance for more than the life expectancy of the insured. So that's one consideration. The other consideration is life expectancy can change. And I know ITM 21st has a service that will produce life expectancy reports for you. So if you have questions about matching up the duration, the coverage duration with the life expectancy of the insured, or if you have had a change in health of the insured, I think it's certainly a prudent part of a decision-making process to get a life expectancy report and include that in your decision-making process, again, where you have those considerations. And something that I don't think is talked about as much, Mike mentioned spreadsheeting of term, which I totally agree with when it comes to fixed premium type products. But one thing that in my experience anyway is too often overlooked is we live in this changing world. Who knew that the estate tax exemption would be $10 million plus when all these ILETs were put into place? And so if there was term insurance in there, and we need to make some changes. We need to change it for a variety of reasons. And there's been a change in health. What's the convertibility? So if not term insurance, question number 4, if not term insurance, what are the choices beyond term insurance? Again, Mike addressed all of these different type of products in last month's call, so I'm not going to do it all again here. The one thing that I do want to highlight that I find to be, again, one of those differences between the fiduciary industry operating system and the life insurance industry operating system is, in my experience, I could never understand why a whole life policy and a universal life policy would have substantially different rates of return shown in the illustration. And similarly, indexed universal life policies now have substantially different rates of return on in their illustrations. In the 1980s, the universal life rates of return were considerably higher than whole life. Now, whole life rates, illustrated rates of return, are considerably higher than universal life. But when you think, and since I knew, because of my fiduciary orientation from my early background, all of these products are backed by the insurer's general account. All of these products are required to invest assets underlying their cash values in high-grade bonds and government-backed mortgages, all of them. So all of these products are going to have to migrate to the performance that you would expect from a high-grade bond, from a portfolio of high-grade bonds and government-backed mortgages, plus or minus whatever the investment manager's performance might or might not be. It just was incongruous to me that you'd look at a whole life illustration at one rate of a substantially different illustrated rate than a universal life illustration, and why that would be from a fiduciary perspective. And the answer is it shouldn't be from a fiduciary perspective. What Mike talked about last week about the rates coming down and causing the type of problems is an example of that it's not true. And that the actual crediting rate will ultimately migrate to the rate of return of the invested assets and underlying cash values. The other options are variable life, private placement variable life, and most recent, there are now products that can do all of the above, or almost all of the above. It's on a variable life chassis, and they have indexed accounts in there, they have guaranteed riders on there, and so there are a small number of products, but I think there's going to be more where it is literally an all of the above option. So how do you choose? Well, if, as I said, ultimately, throwing away the illustration for the moment, if ultimately the rate of return that is reasonable to expect on the policy is determined by the rate of return on invested assets and underlying cash values, then the best way to pick the product is to pick the product where the invested assets underlying cash values correspond to the risk tolerance of the client and the time horizon for the plan and the client's expected outcome. And so this is actually pulled from the best practice standards for life insurance stewardship, and it's easy to remember. So how do you choose which type of insurance is most likely to serve the client's best interest? Just remember the word rate, which will also help you to remember that you look at the rate of return with some healthy skepticism and talk about the reasonableness of that rate of return in the illustration. But just remember the acronym RATE to talk about the risk tolerance of the client, the asset allocations, time horizon, the expected outcome as your guide for choosing which product if it's not term insurance. So if it's not term insurance or it's not a fixed premium product where premiums can change, what causes the changes? Well, despite the varying terminology, insurance industry terminology, with things like paid-up addition riders and extended term riders and dividend interest crediting rates and term blends, and ultimately all of those things come down to three things. And Mike mentioned last month that there's an awful lot of apples and oranges, and it's difficult to see black and white because of all the differences between these products. However, there are three things that are the same in every single product, or there are three things that exist in every single product. So these are the common elements of all life insurance policies. So while trying to understand all the differences may be daunting, there's only three things you need to understand when it comes to what is common in every single life insurance policy, so that you can then consider those things as at least one of the elements of your decision-making process. And those three things are cost of insurance charges, policy expenses, and the investment earnings. As Mike mentioned, whole life was something of a black box some years ago. Sorry, was something something of a black box. It's had been difficult to get your head around these different factors. With the advent of universal life, these factors became available, but they still were challenging to get in many cases. But the proverbial moral of the story from a fiduciary perspective, where there's a duty to incur only those costs that are reasonable and appropriate, understanding this simple formula, again, as a takeaway, as kind of a key takeaway, this simple formula, if you understand this can make at least part of the decision-making process more black and white. Ultimately, the premium or the performance of every single life insurance policy will depend upon how competitive the COIs are, how competitive the expenses are, and how good is the performance relative to acceptable risk to the client. And if this the interest element, which is the one that has been most different in the different product types, if the interest element is overly aggressive here, because there's a minus sign here, it's going to make these look like it's well priced, when in fact it's not, because as this interest element here migrates from the illustrated rate to the more natural rate for invested assets and underlying cash value, then it's going to make these look higher and make the policy look like it's performing, like it's underperforming. And it certainly is underperforming expectations. So what can or should we anticipate in terms of premiums changing? If actual policy earnings are less than expected, at the risk of stating the obvious, given what I just said, Mike also talked about a number of carriers increasing costs. So that's another area. And then changes in life expectancy we talked about. And again, I think that's another area where the life expectancy report produced by ITM 21st would be useful. How do you manage them? At the risk of stating the obvious, confirm that the earnings are consistent with actual performance. Confirm that the expenses are consistent with actual mortality and operating experience. Avoid comparing the hypotheticals. Remember that premiums are not quotes unless, the illustrations are not quotes unless the premiums are guaranteed. And something that I think is useful in at least bigger cases is there is Monte Carlo simulation that is widely used in, for instance, trying to understand the reliability of distributions out of a GRAT. So Monte Carlo simulations are widely used in the financial service business. They are now available for life insurance policies and planning. If you're working with a member of the Society of Financial Services Professionals, they offer a tool as part of their membership to the Society of Financial Services Professionals that performs Monte Carlo simulations on life insurance products, which can be a very useful tool. We talked about in our formula cost of insurance charges and expenses minus interest. So what's being charged inside the policy has been opaque, but it is becoming more transparent. Our mission is to make it more transparent. We already talked about that every insurance policy charges for cost of insurance charges and policy expenses, and we talked a little bit about commissions, which are included in the premium loads. So how do you, knowing what's being charged as part of your duty and incurring only those costs that are reasonable and appropriate are part of the duty. So how do you go about doing that if comparing illustrations is not a good idea according to financial insurance and banking industry authorities? How do you go about doing that? Well, the way that I thought would be useful, coming at it from my days as a pension investment advisory analyst using Morningstar, was, well, let's look at what the average cost is. Let's look at what the standard deviation is. And if we know what the average cost is and the standard deviation is, we know what the worst terms in the market look like, and we know what the best rates in the market look like. And so we can measure when somebody has best available rates and terms, or when somebody doesn't have best available rates and terms. We can measure how much difference there would be, how much cost savings there would be between best available rates and terms and the current pricing, and we can use those cost savings and calculate what the premium reduction would be, or we can use those cost savings to increase death benefits or reduce the risk of a premium call, as we talked about earlier, or for policies that are maybe now underfunded because of some of the reasons we've already talked about, we can use those cost savings to extend the duration of coverage. Or in trust settings, we can use the cost savings to pay trustees' fees. So the way I think about it is the part of the process of professionally managing a trust on life insurance policy is you carry around a ruler and a bag of money, because costs are not very well known, as Mike mentioned last week. You carry around a ruler to measure what's being charged inside the policy. And when you find things are being overcharged, you put that money in a bag and you ask the grantor, what is your intent for this money? Would you like us to use the money to reduce premiums? Would you like us to use the money to increase death benefits for your beneficiaries, reduce the risk of a premium call, extend the duration of coverage, or do you want us to pay your trustees' fees with them? So I also said I'd come back to what's the rate of return that's reasonable to expect. And so I've talked a little, Mike talked a little bit about, a fair amount about what the illustrated rates were. This is a table that's in your handouts that is my take on what the risk profile for the client would be as it would line up with the asset allocation and then the product type corresponding to that asset allocation and the rate of return that would be historical based on historical performance for those, actual historical performance for those asset allocations. Don't need to spend any more time on that. That's in your handout. Just one thing to note, when you're looking at illustrated rates of return on variable life policies, be aware that part of this apples to oranges effect, or part of this apples versus oranges circumstance, is that some illustrations show a rate of return that is gross, that does not reveal fund management fees and insurance expenses like mortality and expense risk charges or M&Es. Some show net of fund management fees but not the insurance fees, and some show net. So you could very easily be comparing apples versus oranges unless you were aware of this gross versus net consideration. So question 8 talks about the rate of return on the death. Question 7 talks about the rate of return reasonable to expect on cash values. Question 8 talks about the rate of return reasonable to expect on the death benefit. Let's say a policy is no longer needed for its original purpose. It was originally for estate planning. The estate tax exemption is now increased. So the consideration is this a good investment? Well, as you can see, the rate of the IRR on the death benefit goes down over time. So life expectancy is relevant to this decision. And again, the ITM 21st life expectancy report would be useful in evaluating a policy held in the trust as an investment rather than for its original purpose, maybe to pay estate taxes. But these rates of return are very sensitive to the life expectancy. In a real life case, the carrier used one mortality table, that is the mortality table for all for everybody, an average of everybody. This was a big trust-owned policy for a high net worth individual, so it was a big policy. Well, the Society of Actuaries publishes a table specifically for big policy. Sorry, the Society of Actuaries produces a mortality table for preferred risks, which then showed that the rate of return would actually be less. And then the Society of Actuaries also publishes a different mortality table for high face amount risks or high face amount policies, which if you were to use that life expectancy, the rate of return would even be less. So again, thinking about life insurance as a trust investment asset rather than for its original purpose, the life expectancy is very important because the rate of return is very sensitive to that. So again, talking about that with your advisors would be a good idea. Question 9 is less, I think less relevant in trust-owned settings, just because it's in a trust and the grantor doesn't have access to the cash value, but it is in an ever-changing world where we had an estate tax exemption change. It's important to understand front-end versus back-end loads, surrender charges versus no loads. Too complicated to get into here, but there are differences in access to cash values between policies that have surrender charges versus policies that have low loads. There are also differences between policies that have surrender charges, but they can be decreased through commission concessions versus no load policies. So understanding those things, again, can be part of a fiduciary process. And if the policy is not needed anymore, or if it's about to lapse, rather than getting no value out of it, certainly considering a life settlement, which again involves the life expectancy insured, and so you would need life expectancy support for that. is something that's part of the liquidity considerations. The last question I'm going to spend almost no time on because it's one that is probably most understood. There are a variety of rating agencies. Some are paid for by the carriers, some are not. They all have different scales. The different scales actually mean different things, and so we would encourage you to use an aggregate ranking instead of looking at individual ratings. Some carriers like to promote one rating over another. I would use an aggregate rating. I would also use ratings as much as anything else as a leading indicator of cost increases, maybe even more so than for financial strength of claims paying ability. There's been no insurance company that I'm aware of that's never paid that has not paid a death claim, but there have been plenty more recently than not that have increased costs. So changes in ratings can be a leading indicator of cost increases. Think about the capacity on big transactions, and on big transactions certainly consider diversification. So with that, wrapping up, you should have in your handout a copy of the 10 questions article from Bloomberg BNA. There's 2 questions that are different. The slideshow will have the 10 questions the way we talked about them, and then there's some additional questions in the BNA article that may be of interest to some of you. I mentioned the Trust and Estates article about the Cochran versus Key Bank case. I think this is, I'm proud of this article. I think it was a very good piece on understanding the differences between the fiduciary investment operating system, the fiduciary industry operating system, and the life insurance industry operating system. You can Google, or I'm happy to send you the investment news article about what advisors and trustees can learn from the Goldman Sachs lawsuit. I mentioned the best practice standards already. It's a 6-step process. Happy to give that to anybody, and also happy to provide anybody with anybody on the call with a complimentary Veralytic report for getting underneath the illustration and looking at the expenses of the policy. And thanks to Mike for mentioning that last week. So with that, all the stuff that we write about, that I write about, is posted on LinkedIn. If you want to follow me on LinkedIn, feel free to do so. The information is there. If you want to email me, you're welcome to do that. Don't use Twitter and Facebook as much, but if you do, feel free to connect with me there. With that, Michael, are there any questions?
If anyone has any questions, just type them in. Barry, I wanted to go back to the case, the Goldman Sachs case for a second, because and I read about it. I don't know, I don't have all the details, but I thought it was an interesting case because essentially, you know, you mentioned it was a huge number. I mean, what they had to pay, and I think that that case is still in play. I mean, are they going to further
appeal?
Deliberation on that case?
It is. So the entity that was sued was the advisory subsidiary of Goldman Sachs. So it wasn't actually a trust company, which could give some solace to trust companies, but you know, an advisory firm actually has a less defined fiduciary duty than the clearly defined duties under the Prudent Investor Act. So in some ways it may be a little less concerning, but in some ways I think it's more concerning because it's a lower standard. Their ACO is the subsidiary. They are appealing. I know both experts in the case, and the challenge is that I think there's 2 takeaways from the appeal. One, even if they win the appeal, did they actually win? Because going through all this, particularly if you're a trustee, you know, you collect what, $2,000, $2,500 in trustee fees. Having to litigate this case, even if you win, you lose. The other thing is that on appeal, they can only argue errors or misinterpretation of the law. The matters of fact are left to the lower court and to the jury because they're the closest ones to the facts and the testimony and the experts. I've talked to the experts. I've talked to one of the experts, and they're both. I think both sides are confident that they're going to win on appeal. But I don't know. I've not yet seen how, on a matter of because they didn't include in their arguments matters of law like Section 7, like Section 2, because they simply said, look, this was a good transaction, and we ran millions of illustrations, and because those things don't have a nexus to fiduciary principles, I don't know how they're going to overturn the case, but I could be wrong.
Well, if I remember this, so this was a variable policy. The performance of the policy was nowhere near expectations on the policy, correct?
It's a variable policy. The illustrations were run at 10% and 0%, and they actually experienced 1% over a 10-year period. So it certainly wasn't close to the 10% expectation.
Right.
But again, in a variable policy, if you were to use modern portfolio theory and say, what is my range of returns expected out of a variable asset allocation, I think 1% would clearly fall within the range, but that's not what they argued. They argued we ran all these illustrations and we did our due diligence. And again, I'm not saying the agent did a bad job. In fact, I know the firm, and I think they did, from a life insurance industry operating system perspective, they went above and beyond. They did a stellar job in the performance of the things that you associate with the life insurance industry operating system, but they were unable to tie anything to the fiduciary industry operating system, which is what the court is going to use as their basis of judgment.
So if you were advising someone who read that, who saw that, what additional services, what additional items would you have done along the way that would have averted the lawsuit? Is kind of where I'm going. What is it that they didn't do that, or what is it that he could have done that would have averted this?
The two things that we talked about today would be the most notable. One, on a variable policy, running a Monte Carlo simulation to say, okay, this illustration shows a static outcome with a linear calculation of a return, which is never going to happen. So let's run a Monte Carlo simulation that's like 1,000 rate of return possibilities, and what's the range of premiums that you can expect? And had the written documentation said, the range of premiums you can expect will be between this and that I think would have been much more defendable. The other thing that I think, at the risk of sounding self-serving, the other thing that would have been much more defendable is, instead of relying on methodologies that have since, albeit the transaction was done before this new guidance was published, but you're fighting an uphill battle when people like you are saying, the only thing I can tell you about this illustration is not going to come true, and that's your decision support tool. So getting in under the illustration and looking at costs, and if they had been able to say, look, we examined the cost of this policy, we measured the costs were competitive, we have a duty to incur all those costs that are reasonable and appropriate, we did that. We have a duty to set reasonable expectation of returns. Here's the range of returns that modern portfolio theory would say that we can reasonably expect out of this asset allocation. Here's the Monte Carlo simulation that says that here's the range of premiums that we would expect. Had they done those three things, I think it would have been a much higher threshold to try to find against the defendant.
And that goes back to some of the things we've said, along the way in all these webinars, and you mentioned today, it's about the process, not necessarily the outcome. And the problem is, when the outcome's not right and the process isn't there, you've got nothing to stand on. And it's something that anyone who is a fiduciary or a trustee dealing with life insurance or anything needs to really understand, is that you have to show that the process you went through was a prudent process and it made sense based on the facts and circumstances at the time. So Well, Barry, listen,
I would add, made sense and connected to, there are 9 sections that are management sections of the Prudent Investor. You connect them to those things, and in this environment, you're no longer low-hanging fruit.
Right, and one of the things I always say, my brother-in-law is a personal injury attorney, and I've had this discussion with him, and I have great respect for attorneys. This is not anything negative. My grandfather, I always tell people, my grandfather was chief judge in Baltimore, so I have great respect for attorneys. But the reality is that attorneys are looking at a case, they're making a business decision on whether or not they're going to take this case and the documentation of the case. And we at ITM 21st have had situations where people have contacted one of our trustees about an issue, and once they've seen the documentation on a case that did go bad, it did not come out the best outcome, but because of the documentation we had behind the decision that was made, we never heard from the attorney again. And I think that that's one of the things that, again, we probably beat on the dead horse too much when we talk about it, but I think it's one of the most important things that we can get across on these webinars or dealing with any type of fiduciary or trustee responsibility. So
totally agree.
But okay, Barry, I appreciate that. Anybody that would like to reach out to Barry, you're welcome to do that. His email is on the screen. Again, Barry, thank you very much, and thank you everybody for taking part in the session today. In 3 weeks, we'll have our last session before our summer vacation. As I mentioned, it's going to be a great session dealing with the Department of Labor fiduciary regulations, so that'll be a great discussion. Thank you, everyone, for taking part today, and we'll see you in a few weeks. Thanks a lot.
Thanks, Mike.